Hey everyone, and welcome to this explainer on Module 4. Today we're kicking off part 1 of a 3-part series where we really dive into vicarious liability, specifically focusing on this super fascinating doctrine called sovereign immunity in torts. We're going to cover what this doctrine actually means, exactly where it comes from, and the different types of immunity that fall under it. Here's our roadmap for today. First, we'll look at what sovereign immunity actually is. Second, we'll trace the doctrine in India. Third, we'll break down the 2 types of immunity. And finally, we'll wrap up with immunity to jurisdiction.
Okay, let's jump right in. Section 1. What is sovereign immunity?
So at its core, sovereign immunity is essentially a justification for wrongs committed by the state or its representatives, and it's based entirely on grounds of public policy. What that actually means in practice is kind of wild. It means that even when every single element of an actionable legal claim is present, like you have a rock-solid case against the government, they can still avoid liability completely, just by invoking this justification. It acts like an incredibly powerful shield. Now, this immense power doesn't just come out of nowhere. It's deeply rooted in a common law principle that we borrowed from British jurisprudence, and is perfectly summarized by this ancient Latin maxim, rex non potest peccare, which literally translates to, the king can do no wrong. See, historically, because the king held all these various powers to regulate his role, he was protected from punishment. The basic practical logic was that he needed to be able to run the state efficiently and effectively, without constant legal disruptions holding him back. Because of this idea that the king, and by extension the state itself, literally cannot commit a legal wrong, well, it means he can't be guilty of personal negligence. And following that exact same logic, he can't be held responsible for the negligence or misconduct of his own servants either. So in short, the sovereign is just totally immune from being sued in civil suits and immune from criminal prosecution. Plus, as a fundamental attribute of sovereignty, a state simply cannot be sued in its own courts without giving its explicit consent.
All right, moving right along to Section 2, the doctrine in India.
So this doctrine actually held tremendous sway in Indian courts starting from the mid-19th century, and it stuck around until fairly recently. But as you might imagine, whenever a genuine claim for damages was brought before the courts and then just completely refuted by this ancient, seemingly irrelevant doctrine, well, it created massive public resentment. In fact, the Law Commission of India recommended abolishing this outdated doctrine altogether in its very first report. But for various reasons, the draft bill for its abolition was never passed. And that basically left the whole question of whether this doctrine was even compatible with the Constitution of India entirely in the hands of the courts. So how did the judicial system actually adapt to that legislative standstill? Well, to avoid defeating those genuine claims we talked about, Indian courts did something quite clever. They just kept narrowing the scope of what actually counted as a sovereign function. By shrinking that definition of what the state could claim immunity for, they ensured that victims could still successfully receive damages. Oh, and before we go any further, it is definitely worth flagging Article 300 of the Constitution of India. This article explicitly spells out the liability of the union or the state for acts of the government. This is a super critical piece of the puzzle, and we are going to return to it deeply in part 3 of this series, so just keep a mental bookmark right there. Let's transition into Section 3, 2 types of immunity. Generally speaking, there are 2 main types of immunity that a state and its representatives benefit from. Let's look at them side by side, comparing the conditional, restricted nature of qualified immunity against the impenetrable shield of absolute immunity. First up is qualified immunity. Now, this protects a government authority or an official who is acting within the scope of their employment, doing so in good faith and without violating statutory or constitutional rights that a reasonable person would be aware of. Practically, it shields state and local officials, most notably law enforcement officers, from individual liability. The only exception is if the official violated a clearly established constitutional right. Interestingly, this doctrine traces all the way back to 1871, when the U.S. Congress adopted a specific law making government employees personally liable for money damages if they violated federal constitutional rights. So it is a strong protection, but it has firm boundaries. The second type is absolute immunity. And this one is far broader. It completely bars a lawsuit. Like, absolutely no exceptions. It fully immunizes government officials from criminal prosecution and civil suits entirely. Because it's so sweeping, you don't see it everywhere. This type of immunity generally applies only to specific figures across the government, such as prosecutors, judges, legislators, and key executive officials. Moving on to our final segment, Section 4, Immunity to Jurisdiction. Now, this brings up a highly critical question.
How exactly does sovereign immunity work if a state authority or government official commits a wrong in a completely different state? Does that immunity just pack its bags and travel with them?
The answer really stems from a distinct concept called immunity to jurisdiction. This is the core idea that it would be, well, highly inappropriate to call one state's entities under the jurisdiction of another state's courts. In other words, a state is generally immune from being tried in the courts of another sovereign state. It's all about mutual respect of sovereignty. Let's look at a hypothetical scenario to make this concrete. Say a person from India commits a crime in America. Because India is protected under sovereign immunity, India is not under an obligation to submit that person to a trial in American court. The state where the wrong was committed just cannot force the other sovereign state into its legal jurisdiction. That said, this immunity isn't some permanent, unchangeable wall. A state entity can voluntarily relinquish it. Very often, courts will treat a state's formal agreement to enter into international arbitration as sufficient proof that it has intentionally waived its immunity to jurisdiction, and that allows the dispute to be heard fairly outside of a foreign domestic court system. But the geopolitical reality of that arbitration process is a bit complex. Certain developing countries remain quite hesitant to submit themselves to international arbitration. They have this very real fear that it won't provide a fair hearing and that the whole system is heavily dominated by Western principles. However, a practical middle ground has emerged. Many of these developing countries feel much more secure submitting to arbitration specifically under the UN CITRAL rules, which offer an internationally recognized framework. Okay, so we've covered the origins, the types, and the international implications, which leaves us with a massive, lingering question as we wrap up this explainer. How did this ancient, slightly unfair relic of a doctrine, born from the idea that the king can do no wrong, actually manage to evolve and survive alongside modern constitutional rights in India? Well, that is exactly what we are going to explore next. In part 2 of this series, we will trace how this exact tension was resolved, moving from the pre-constitutional era right up through some incredibly landmark Supreme Court judgments. Does the state still hold the ultimate get-out-of-jail-free card today? Join us in part 2 to find out. Thanks for joining us today, and we'll see you there.